As many of you already know, the Deason Center is an academic research and advocacy center located at SMU in Dallas, but we work all over the country. Our primary issues are, of course, centered around the right to counsel, particularly on day one. We think and talk a lot about all the things that ought to happen within the first 24 hours of somebody being arrested and the things that should continue to happen up until charging time and beyond. And so that's exactly the sweet spot that Professor Primus is going to be talking about. We also do a lot of work on public defender workloads. We think and work on issues related to practice in small and rural areas, and particularly how the right to counsel is systemically delivered or not in those smaller and more rural areas. And we do a little bit of work on prosecutorial charging decisions, which, as many of you know, often drive these delays in the appointment of counsel. So we do these workshops every month or so, and they're opportunities for scholars to present works in progress. And we love having what is a very robust audience, and I can see we have it today, that includes both academics and practitioners, so that our scholars have an opportunity to share their work with and gain insight from people who are thinking and writing in the field, and just as importantly, people who are laboring in the field. And I'm happy to see so many of you from both of those communities. So with that, I want to turn to our workshop. I'm going to ask Professor Primus to present on her paper for about 20 minutes, and she'll walk us through it with some slides. And then I will moderate a discussion. You're welcome once we start that to raise your hands. I'm going to tell you now two important facts about our Q&A. One, I am going to ask you to turn on your cameras because we all know how awful it is to talk to a blank screen. So I'm going to let you leave them off while she's presenting. But once we start to have conversation, I want to see your bright and smiley faces. And second, as many of you know firsthand, I am still a professor and I will call on you to turn your cameras on if I don't see them, because I have no shame. So with that, I'm going to hand it over to Professor Primus, who probably needs no introduction, but let me just say briefly. She's not only a professor of law at the University of Michigan, but she began and has very successfully been the Public Defender Training Institute, which really seeks to drive at the highest levels of legal education, a movement to prepare students for public defense. And along the way, I think symbolically, and I mean this in a good way, symbolically and very importantly, is signaling that the highest and most prestigious levels of legal practice, public defense is a valued and valuable profession that is respected, admired, and encouraged in the nation's most prestigious legal institutions. And so with that, I will hand it off to Eve. Take it away.
All right. Well, thank you, Pam, for inviting me to be here and for the opportunity to present this work in progress. And thanks to all of you for taking time out of your busy days to join. As Pam said, this is a very timely project in that the draft that I circulated was circulated to you just a few days before the Oregon Supreme Court decided its most recent case involving unconstitutional delays in the appointment of criminal defense counsel. So that's not included in the paper, but I will include it in the talk and in the later versions of the paper. And I am at a very early stage of this and am very interested in getting your feedback and reactions. And so maybe I will just set it up for those of you who didn't have as much time to do a deeper dive into the paper by describing, right, what is the problem here? Some of you know all of this already, but we have 4,000 people who were waiting for counsel in Oregon as of just a few weeks ago. People who were charged with committing crimes, who were deemed eligible for indigent defense representation, but who they did not have lawyers to give them. So they were just sitting, sometimes in jail, sometimes on restrictive conditions. 7,200 defendants were unrepresented in Massachusetts. 1,300 of those were in custody. Thousands of people have been on wait lists in Missouri, Mississippi, Wisconsin, Maine, and other places around the country. So this has become a national problem, not just a local problem. You see it ripped in the headlines these days, right? This is about Mississippi's public defender system being in crisis as people there are waiting years for lawyers. Like, this is not you're waiting just 2 days. This is weeks, months, and years for lawyers. It has gotten so bad in Mississippi that lawyers have a nickname for it. It's called the dead zone. where people just don't have access to real counsel. Unless you think it's just a problem in the South, right? This is a headline ripped out of Wisconsin. 3 years and more than 10,000 lawyer calls after being charged. A Wisconsin woman still did not have a defense lawyer. So this has been happening for a while now around the country, but it actually has gotten the attention of courts recently. So in Massachusetts, back in 2004, they developed a protocol called the Lavallee Protocol, where they would drop charges if people were being held for too long. That is now happening again in Massachusetts. Maine has issued relief for unrepresented defendants. And as I mentioned, Oregon, very recently, February 6th, right, is dismissing criminal cases because of these delays. And so what I'm trying to do is intervene in this moment when we're starting to see this momentum happening toward both paying attention to the delay problem and taking steps to address it, to do a deep dive into both why the problem is happening, what exactly the problem is as a legal matter, and what are the best litigation strategies in other states for trying to address it, learning from this first wave of litigation. So I'll just start quickly with the why is this happening? Some of these are really obvious causes. Like, obviously, we underfund indigent defense drastically around this country, and it means we don't have enough money for defender offices to hire enough lawyers, which means as there is more criminal charges that are brought against individuals, they don't have enough people to do it. That's connected to the overcriminalization problems we have in this country, which leads to this shortage of attorneys. I don't mean to belittle those three huge problems. I think those are the three things that everybody points to when they think about delays. Sometimes they also discuss problematic local procedures. Like Mississippi, I talk about, has this weird when a lawyer gets appointed, and up until 2023, there was this zone where people weren't getting lawyers, and it was taking a long time to charge them because of problematic local procedures about how grand juries were constituted in that state. Sometimes people will mention those, but really it's underfunding, overcriminalization, and this attorney shortage. And in the defense of these lawsuits, this is what people will always say. There just aren't enough lawyers. There just aren't enough lawyers. And that's true, that there is a shortage of lawyers. I don't mean to belittle that, but I think there's something that's getting lost, and it's about the structure of indigent defense delivery. I actually think the structure of the delivery systems exacerbates the problem. If you look at the jurisdictions where we're having the biggest problems with delays in appointment of criminal defense counsel, they're systems that rely heavily on contract or assigned counsel systems rather than institutional public defender offices. So this chart is in the article. I sort of condensed it here. But if you track, right, all of these jurisdictions and states where we're seeing delay problems, they are relying very heavily on volunteer or assigned counsel or contract, low bid contract kinds of models for indigent defense rather than full-time institutional defender offices. That, I think, is a heavy contributor to this problem. And I explain in the article why. It builds on another article I wrote about the problematic structure of indigent defense delivery. I actually think first, it just results in some inherent delay when you don't have an institutional office that can get the appointments and immediately farm them out to the lawyers who are on assignment in the office. In some of these jurisdictions, they have to make phone calls to all of the available lawyers. The lawyers are not required to take the cases, so they have to ask them if they can take the cases. If they say no, they have to go to another lawyer, and this takes time. This, for example, was one of the big contributors to delay in Maine that relied heavily on an assigned counsel system where lawyers were not forced to take the cases and they had to do this kind of outreach. I think it's the payment rates for these lawyers that contribute to the shortage of lawyers that we have. It is no surprise that we pay abysmally low hourly rates to indigent defense lawyers who take cases on through assigned counsel programs. This has been historically true. It is still true. And lo and behold, when you pay nothing, you do not get as many lawyers who want to do it. And if you rely heavily on an assigned counsel model or a low flat fee model for taking cases where you only pay a small amount per case, you just aren't going to get as many lawyers who want to do that work. So take Massachusetts as an example of this. They've had 3 different crises, at least over the last 20 years, where they've had to institute the Lavallee Protocol, that is the judiciary's response to when there's a delay problem. Each time the legislature raises the assigned counsel rates dramatically for a period of time, and it fixes the problem. It's not that the lawyers weren't there, it's that they didn't want to work for free. And then over time, they wind up paying them less again, and then it explodes. So I think inherent in our private counsel world is that we don't pay lawyers enough, and that contributes to this problem. It's also the case that when you have assigned counsel or contract lawyers who don't get loan forgiveness access, fewer of them go into indigent defense. There's just a ton of research about how much it costs to go to law school these days and how many people are taking out massive loans. And unless you work full-time or close to full-time for a real public defender office or an office that has a relationship that is a nonprofit, right, you're not going to get access to these loan forgiveness programs. It's also the case that in a lot of the private counsel systems, they do not have the same recruitment, training, and retention policies that institutional public defender offices have. And I should pause here and say, yes, I am making generalizations. There are models that are better and worse along this dimension. Like the more managed the assigned counsel system is, the better able it is to reduce administrative delays or to increase training and recruitment policies. The less well managed it is, the worse it is at doing those kinds of things. But on the whole, none of the assigned counsel or contract systems are as good as the institutional defender offices along these dimensions. And I think that contributes substantially to the problem of not having enough lawyers and not having the ability to appoint people promptly when their Sixth Amendment right to counsel attaches. So I think one contribution I hope I'm making in this is to highlight that one of the things, if we care about these delays, that we really need to do is try to push or incentivize jurisdictions to rely more on institutional defender offices for larger proportions of the indigent defense caseload to the extent that that is possible. Institutional defenders, I think, also are really good at pushing back on a lot of those other problems too. So you'll see around the country, it used to be back in the day, there was this sense that institutional defender offices just represented individuals. They now have structural roles in lots of jurisdictions. They lobby for more funding. They collect data for more funding. They lobby against overcriminalization. They attract lawyers from out of state to the jurisdiction, and they advocate to fix problematic procedures that cause delays. So I think having institutional defenders also can help, right, along some of those other dimensions as well. One other thing that I try to do in this article is push back on some of the arguments that people have made that these delays aren't legally problematic because all you're doing is pausing a prosecution. And as long as nothing important is happening during the pause, then it's fine that you don't have a lawyer for an extended period of time. I think this is just flat out legally wrong. And so I put in the article a description of this. Obviously, basic Sixth Amendment law is that you have a right to counsel at critical stages. The United States Supreme Court has not done a great job at defining what critical stages of a prosecution are, but I do have a section in the paper where I sort of go through all of the Supreme Court case law and try to synthesize it into what I think is a 2-part disjunctive test for critical stages. So I think whenever the accused has to make a decision that requires them to navigate the procedural and substantive intricacies of the system in circumstances that could affect the ultimate outcome of the case, that's a critical stage. There's just a bunch of case law, I think, to support that. But I also think it is the case, based on Supreme Court case law, that if you have a prosecutor or a prosecutor's agents and they're engaging in an activity that might settle the accused's fate at a later trial or plea, if counsel isn't present to protect their interest, that's also a critical stage. It doesn't have to be like a trial-like confrontation. And so I say, if you lay out this test, it's really clear that you've got a bunch of critical stages happening in the first 30 days after a person is charged. You've got various state procedures with dispositive hearings that are going on. You have a critical pretrial investigation period where you're losing important evidence, access to technology, access to, crime scenes where things could disappear, witnesses could disappear, etc. And so I think saying I'm pausing this is not going to sufficiently get you out of a Sixth Amendment problem. I also make the argument in the paper there are due process and equal protection problems with these delays, as well as statutory and court rule violations in a number of jurisdictions. So I think it's legally problematic at the federal constitutional level, state constitutional level, and at state statute and court rule levels in lots of circumstances, as well as federal statutes. So there's a section here where I say this is not something that you rely on speedy trial to handle. This is actually a problem independent that has to be addressed. And then the other big thing is to look at the current wave of lawsuits going on and talk about solutions. So one thing that we've seen, because we've got a number of states where there has been successful litigation on this, is one thing litigants are doing is they're bringing 1983 lawsuits. And these actually have been effective. A lot of people are very, very skeptical of structural reform litigation through 1983 lawsuits. These are in state court. And I think that there are a couple of things about delays that make 1983 lawsuits easier than some of the other Strickland-like lawsuits that we see. One is it's just so clear what the violations are. Like, these are not investigations that require a ton of factual development. You just can show when someone's Sixth Amendment right was triggered and how long they've been waiting for a lawyer. And then it's just a legal question. It doesn't require a ton of factual development. So there are a case called David in Missouri, which was a trial court level case, was a Section 1983 like lawsuit in state court where the judge said, yeah, I think you can't delay appointment this way. And I'm going to say you've got to dismiss without prejudice these cases after 2 weeks or whenever a critical stage is going to happen if it's before that, using 1983. You also have the most recent trial court decision in Maine in the Robbins case. That was a 1983 lawsuit. And the state trial court essentially gave the state a month and said, I want you to come back and tell me how you're going to fix this delay problem. And within a month, they had reduced the number of people who were still waiting for lawyers from hundreds to 6 people. And they had a plan. They had a plan for how they were going to do more outreach, how they were going to develop more public defender offices and rely less on assigned counsel systems, how they were going to streamline the appointment processes. So structural reform litigation in action in Maine, and it has really catalyzed the development of public defender offices there. Other things that have been going on in addition to the 1983 lawsuits are common law writs. Habeas writs, superintending control writs, mandamus writs, and this is where there's been a ton of action as well. I already mentioned the Lavallee case from Massachusetts. This is the oldest one. It started back in 2004, and the Massachusetts High Court said, we're going to use a writ of superintending control that we have available to us under our state law, and we're going to say, as a matter of fundamental fairness, you need to release people, right, if they have been held for longer than 7 days, and after that, you need to dismiss without prejudice these cases once they get, right, to 45 days without lawyers. And that was done under a superintending control writ. You've got the most recent Ninth Circuit decision in Betchart, which came out of Oregon, relying on a federal habeas class action to say people have to be released within 7 days if they have not yet been appointed counsel and they are being held in jail. Robbins in Maine had, in addition to the 1983 lawsuit, also a writ. It was a state habeas corpus writ class action there. And they said, using the writ, that you have to dismiss cases after people have been held for, it was longer, 14 days, right, in that jurisdiction, and then dismiss after 60 days. And then most recently, in February, the Roberts Oregon Supreme Court recently held, using a mandamus petition, that if you are remember, you already had Betchart that released people after 7 days if they were in custody. So Robert sort of picks up where Betchart left off, and using mandamus said, after 60 days, if you still don't have a lawyer, we dismiss without prejudice if you're facing a misdemeanor. And after 90 days, we'll dismiss if you're facing a felony. So you can see use of both 1983 and these writs to try and push states along. When I was looking at this in the paper, like just comparing the solutions, I think, it's not shocking. The 1983 lawsuits are slower and the writs are faster. That's just an inherent nature of these vehicles. You get lots of procedural obstacles to the 1983 lawsuits that come from class certification, standing right doctrines. If you're going in federal court, you're going to hit abstention doctrine. You're going to get a lot of litigation about who are the right people to sue under 1983. And all of the commonality, typicality kind of requirements that come from class actions take time to litigate. And in all of these lawsuits around the country, you will see that those kind of mini issues playing out, and some will fall. Like Louisiana tried a class action and lost on the class action certification. Wisconsin is fighting it now, right? They're, in the throes of fighting about commonality, typicality, right, et cetera, under the class action requirements. So these are slower. The writs, they often don't have nearly as many procedural layers to them. It's clearer who gets sued under the writs, right? And they tend to operate faster, at least, than the 1983 lawsuits do. The other thing that's different about them is the 1983 lawsuits, because they are structural reform-like, tend to be more about prospective relief, right? They think about system design. They do things like the Robbins trial court did and say, come back in a month and tell me like what your plan is for how to fix this. Whereas with the common law writs, they tend to be more retrospective. They're like, there's a problem we have to address of people being held right now. And we're going to give solutions that are levers, right? Like we're going to say release and dismiss without prejudice at certain points. That will solve the problem of the current person in front of you. And it provides a catalyst or an incentive for the system to fix the larger structural issues, but it doesn't fix them itself. In the end, I have made the argument like, look, to shoot your best shot, you got to combine them, right? And in some jurisdictions, when you're going to hit obstacles with a 1983 structural reform, maybe you're going to need to rely more on some of those common law writs. I think the writs are underused. It's recent that people have started using them, and I think they have a lot of power, and there's a lot of fodder for conversation there. So I have gone for 20 minutes. I will shut up there because I am most interested in your feedback. So that's the idea. Hit me with your best shot and tell me what I'm doing wrong.
All right, Eve, thank you so much. I'm going to ask y'all to go ahead and take a minute to turn on your cameras. Yes, I know some of you are eating. You'll get a temporary pass, but please turn on your cameras and join us. If you'll drop your questions in the chat or raise a hand, it's entirely up to you. If you want to pull down your PowerPoint, and that way we can all see each other a little better.
Yes.
And I'm going to, while people are getting themselves settled, boy, do I see a lot of familiar faces. I'm going to take a minute and you exercise the moderator's privilege and ask you if you could speak for a moment about the nexus here between the success of these litigations and the success with which defender offices maintain and keep data. And I'm saying that in part because one of the points you make in your article is that one of the challenges to non-institutional defenders is that institutional defenders can collect data. So, Jordan, I'm looking at some of you. Collecting data remains, I think, a very significant challenge for people at the state level, even in institutional defender offices. Mm-hmm. And I think challenges to, one, claims that my workload is too high, and two, the data underlying workload claims are becoming obstacles to some of these litigations. And I will confess here that the Deason Center's policy director, Malia Brink, as I speak, is, I believe, testifying right now in Portland, Oregon, or if isn't testifying at the moment, maybe he's on a lunch break, about the National Public Defender Workload Standard. So it's something we think a lot about. What is your thinking about how workload data and workload ethics claims play into the success or lack thereof on some of these litigations?
So, I mean, I will say, I think the data I'm talking about with respect to this specific area of litigation is not workload really related at all. Like the relevant data is the length of delay, right?
Okay.
Because and it actually it works to the benefit of the litigants to try and stop delays here because you don't have to get into what I know is like a messy national conversation about how much weight to give the workload standards or not when figuring out about allocations. I think here, if the data shows I've got X number of people whose Sixth Amendment right to counsel has been triggered at a first formal hearing, and they are waiting Y period of time, right?
Okay.
And we have not been able to give them lawyers, we find constitutional violations because prejudice is presumed when you don't have a lawyer at
Got
a
it.
critical stage. So I think here the data is cleaner. And that's why you see
Hmm.
so many judges, prosecutors, governors like
Right.
around the country saying this is a big problem, and being more willing to intervene and grant relief on delays than they might be on sort of traditional Strickland claims. Now, I will also say, though, that, my push to have more institutional defender offices is in part a push that says like those offices will be able to collect the kind of data you're talking about with respect to workloads, with respect to caseloads, with respect to like, recruiting, et cetera. And they will be able to lobby legislators for more money, push courts, right, to do things
Hmm.
that are more advantageous. And that's where we will get into the sort of murkier data can be helpful, it can be, sometimes tricky to navigate, et cetera. But I think it will be, regardless, it will be better than it is now in those jurisdictions that don't have as many institutional defender offices, because I think you will be able to shed more light on the nature of the problems and push than you do now, where you have these very disparately organized systems that can't collect anything and don't even count a case the same way.
Right. Got it. So the floor is open if folks want to raise their hands, or if you're feeling shy, I guess you can put something in the chat, although it's a room full of public defenders and academics, so I don't expect much shyness here. If there isn't anyone who has a question immediately, I would like to follow up with a kind of a related question, which is, what was your thinking behind the choice to focus solely on the first wave of litigation rather than some of the other structural reform that's been tried outside of the litigation, especially given the, how shall I describe it? The somewhat alarming state of some of the federal courts. Is that a fair way to describe it?
Yes. Well, you'll notice I push for state litigation
I did
more than
notice
I
that part.
do
Yes.
federal litigation.
Yes, but 1983 made it. Yeah.
Yes, but I mean, it's in state court, right? So I think, look, and you're not the first person to ask me this question. I think part of the answer, the cop-out answer, is going to be space, right? Like in an ideal world, I would
Yeah.
also talk about, possible like policy arguments and initiatives to try and fix this. I do have a section at the beginning of, I think it's part 3, right, where I say, like, here's the issue. Like, these delays are now occurring and have been occurring in really problematic ways for enough of a period of time now that if the political branches could get it together to fix it, they would have. And like you see that in a lot of these jurisdictions. If I take Maine as an example, like they were trying, right, to like, they were saying we have that's a completely assigned counsel system in our state. We cannot get enough lawyers. We're having these problems doing appointment. That they were at a negotiating table with the state agencies that were responsible for implementing indigent defense there. They tried to get more money from the legislature. They tried to appeal to the governor. And like part of this is just like, look, it's not, I mean, I'm not saying anything this audience doesn't know, but like it's not super politically popular. And the biggest problem is like you can make the argument that public defender offices are better. And I make that argument all the time. They're cheaper, right? And there's a ton of data to demonstrate that they're more cost effective over time than assigned counsel systems. But the problem for current legislators is those cost savings occur over time, right? It does require upfront investment in the brick and mortar buildings and the infrastructure of the office. And that's where politically you just hit a lot of obstacles. I suppose I'm coming in at the point of saying I'm assuming political failure because that's what we're seeing
Okay.
in all of these states is political failure to address the delay problem because nobody, not even the prosecutors, the governors, the judges, like nobody says, oh, it's really great that we have these massive delays.
Right.
Right. It's that way. It's unlike Strickland. Like we make
Right.
these class action Strickland claims, and there are plenty of people who make the argument no, they're getting effective representation, and there's a fight about whether it's effective or it's ineffective.
Right.
Here, everybody recognizes problem in the delays.
Right.
They just can't fix it. And that's where I think the courts have an important role to play to make the push that requires the fix. And so that's sort of why I focus on that part more than the others.
Do you think, Eve, therefore, that the litigations look different in the states that provide a right to counsel at initial and or continuous than those that don't? And I'm thinking here not just about the transition in Mississippi from the 2023 rule to present, but and Greg, I know you're here, you don't have to say anything, but a state like Arkansas, where the criminal procedure rules provide for counsel, but the state hasn't been provided. I think it would be the public defender's position that they haven't been provided with sufficient resources to be able to do it. And I think that's a fundamentally different litigation posture, perhaps, than one of the many states that do not provide for the right. And then, Colin, I'll come to you.
Yeah, I mean, I actually I don't see a huge difference, interestingly, between the states that have. I think the states that have early access to counsel by way of state constitutional provisions, statutes, or rules, there's a stronger claim for what's legally problematic. Like they don't have to go to the Sixth Amendment critical stage
Right.
argument. But I think regardless, like in a lot of those states, like, they have counsel at initial appearance, but they're for that day only or for that moment only. Like you see this like in lots of
Right.
different jurisdictions. And I've made arguments that, look, I mean, that might solve that moment, but there's tons of critical stages that are coming shortly
Right.
afterwards where you don't have the lawyer. And I think in some respects it's worse in some of those states, like in Maine, they have a
Yeah.
lawyer of the day. And like the judges kept saying, but you have the lawyer of the day. Like, doesn't that solve everything? It's like window dressing
Right.
on the right to counsel problem. And so you have a little bit more of a uphill battle in the storytelling to explain why those lawyers who show up, meet the person for 5, 10 minutes,
Right.
do a bail argument, and then are gone are not sufficient to satisfy all of the critical stages that occur like in the first 30
Right.
days of a case.
Right.
And so it kind of cuts both ways for me.
Episodic lawyering versus continuous lawyering,
Yes.
regardless of whether it's a smooth handoff between your attorney of the day, and some of you are working with some forms that the Deason Center built for those handoffs, or whether it's, the true abandonment, right? Attorney for
Yeah.
the day and sayonara. Colin, where are you? I lost you on my screen.
Hi,
Hi.
Colin. Long time no
Hi.
see.
Yeah, good to see you both. I'm in Oregon, um, and I'm wondering how in your paper you're thinking about the kind of push-pull between the solutions with this kind of litigation and the potential political response to say, well, we've been letting you say we need effective representation, but now the courts are saying we got to give them lawyers. So we're just going to say lawyers take more cases.
Yeah.
Uh-huh.
And now we've got in Oregon, there's different litigation happening also around that. But just in general, a solution to the lack of counsel that just maintains the same pot of lawyers, you know, it's whack-a-mole. So I'm
Yes.
wondering how you think about that in the paper.
Yeah. So I have a section, I think I would put that in the I guess what people I have it right now in the 1983 context, but I think I could apply it more broadly, which is retrenchment, right? Like the problem is you win this victory and then you're going to get pummeled, right? On other areas of law. I think, look, yes, that's a problem. right? And I don't doubt that it's going to happen. I don't doubt that they're going to say, all right, we are now required to provide lawyers, so we'll put bodies with law degrees in there.
Right.
And we won't do any quality control, and we won't. And I think what will happen is that will then be sort of like the next stage of the fight, right? Is to say, well, a warm body with a law degree who shows up at the very last minute is not an effective lawyer. And there's law to support that. It gets harder, right? But I do think to the extent, look, my hope is this will also push states like Oregon to recognize the system that we have had thus far with all of these contracts all over the state in all of these counties and a smattering of institutional defender offices, but a lot of other is not viable long term because it's going to be real hard to even get the bodies that quickly in a lot of these jurisdictions. And the argument that I make in the paper is I get that there's going to be a retrenchment or pushback anytime you recognize a new right in this area. But if our baseline right now is a bunch of reliance on dispersed assigned counsel / contract systems and less reliance on institutional defenders, and we can use this moment with respect to the delays to catalyze and push so that we move to more institutional defender offices. We'll never have all institutional defender offices, but we'll have more. Than when the retrenchment hits come, right? There will be institutional bodies that can push back. And I think that's better. And so like overall, I think status quo will be improved by virtue of doing this. I'm not saying there won't be future fights. But I do think Pam and I were just talking about like the pilot project that they have going, right? In Mississippi, where they have people coming in at initial appearance and they're wildly successful. You look at Partners for Justice, right? Emily Galvin-Almanza's organization. If you get advocates in early and you get people out, it has huge downstream effects. So if I'm thinking about where I want to allocate the resources, I'm happy to push for more early representation for all the reasons why I think there are critical stages there.
So, Eve, I'm going to jump in and just say two things. One, we have a rule in my office, which is we call it prompt representation and not early.
Okay.
And the reason we say it that way is because it's our position that you have a right to counsel at initial appearance, period. But one of the nexus between the question Colin is asking about the workload pushback, which is the answer is if you don't have a lawyer, just make the lawyers take more cases, right? And the point you're making about functional lack of representation. The nexus and the irony here is good lawyering on day one will reduce everybody's caseloads. The earlier you have a lawyer in there who's asking questions, who's reviewing evidence, I don't want to call it triage because that's not in fact what it is, right? It's not deciding which cases do or don't need attention, right? It's making good decisions about which cases can be resolved and then handling them, right? But also getting cases out of the system. That's one piece. The other piece, and I had a comment in here and it was made just to me, so until this person volunteers themselves, I will share it. Is that the other big problem is the delay in charging. And so just to kind of flesh this out, those of you who are coming from federal jurisdictions or mostly from the western part of the United States, this is not a familiar phenomenon to you. But in many, many states, the state has a lengthy period of time in which to make a decision whether to file formal charges. So the cops come in and prosecutors, for example, in Louisiana and Arkansas have 60 days that they can hold you in jail on a felony before deciding, gee, I'm very sorry, we're not going to prosecute that case, or before they file. And in many jurisdictions, it's filing that triggers discovery, for example. It's also filing, by the way, that lets you answer the fourth Barker prong. What was the prejudice to your case? Because it's hard to file a constitutional speedy trial motion if you don't know what you would have been tried on. And so I think the argument that this person is making, and again, in Mississippi, Oklahoma, Alabama, there's no charging deadline. Once you've been arrested, the state can take as long as it wants to decide whether they're going to file formal charges and try you. Is that because prosecutors have so long, it's very difficult to persuade judges and lawyers who may not be as well educated that there's anything to be done in that period. So in Mississippi, the term dead zone comes from the idea, not that there's no lawyer, but that there's nothing to be done anyway. It's dead because there's nothing happening. And it's a fundamental lawyering failure. But that question that Colin asked about, how do you manage the fact that they're just going to say take more cases? I think is a very significant structural challenge that requires rethinking front end practice as a way of downsizing systems. Dolores, did you want to, and to the person who put that comment in, if I did not do your comment justice, then hit me back and I'll say it again for you in a different way. Dolores.
Yes, thank you so much. I apologize, I'm eating lunch. But I do, right now, something was presented, and I think I forgot half my question, but it was where you said the advocates are showing up in court and getting them out early. Is this through like a community bond or participatory defense, or getting the judge to release on their own recognizance? How exactly are they getting them out early?
So,
You said don't use that term, and I agree, but I'm just trying to remember the words to connect the question.
yeah, maybe I made a reference to Partners for Justice, right?
Yes,
Where they
yes.
embed advocates. What they do is they embed advocates who do essentially like a mitigation workup that enables the lawyers at early bond hearings to tell stories in more compelling ways that then convince judges to release more defendants pre-trial. And so it is essentially like having more mitigation specialists at the front end rather than solely at the sentencing end.
Okay, thank you so much.
And Paul Heaton just did a spectacular study on this.
Yes.
It's not published yet, but the data are staggering. And David Anderson from my office, who's here somewhere, if you're interested in understanding what lawyers are doing on day one through that project, David can tell you more about it in Mississippi. But Paul Heaton has done amazing. I mean, Paul Heaton has amazing results on what the Partners for Justice advocates have done.
Yeah. I mean, I will also say, like, for the discussion, Pam, that you mentioned with the person who was in the chat, like, I agree that the delays in charging are massive problems. One thing I'm hoping, and I'm interested, right, in whether you guys think, especially those of you who've got, a lot of practical experience in doing these cases, is I faced in earlier iterations, I had a version of this that said essentially, at the initial appearance or shortly after is the first critical stage. And so you need lawyers from that point forward continuously. And that's sort of what the main trial court said, continuous right after that point. And there were a lot of people who pushed back, and I think rightly, and said, look, the pretrial process for a lot of felony cases can take years, right? Like, what if, there's a slight delay, like a lawyer leaves and you have a month before you get another lawyer, but it's like a year and a half into the case and nothing is going on. Are you saying that suddenly there's a Sixth Amendment right to counsel violation because there has not been continuous lawyers at all times at every moment? And I thought, like, no, I mean, I think it's possible that you could have a blip somewhere, right? As long as there wasn't a critical stage. It wasn't. And that's when I tried to talk about the delay in charging doesn't address what I think is the critical pretrial early investigation period, right? And maybe I should call it prompt investigation. You're making me rethink, Pam. So I tried to think like, okay, how do I do this? 30 days, which is what I said, is kind of arbitrary, right? I could have said it at a different time. I'm curious whether you guys think that's right. But I think that the combination of technology erasure, which happens at the beginning, the way crime scenes, right, are destroyed or played with, and the way environmental factors and other things can degrade evidence, witnesses disappearing in memory loss. Like, I thought that first 30 days, I don't care if you've yet been charged. If you've been arrested and you have a Gerstein hearing in court, that's going to be triggering of the Sixth Amendment, right? And so you're going to have a Sixth Amendment right. And if that first 30 days is critical, it will force jurisdictions to give you lawyers, right, in that beginning stage, and which will do benefits for all the reasons that we've been talking about up to this point. I do think the Supreme Court has not yet fully recognized the pretrial early investigation as a critical stage. There's dicta, right, in Powell versus Alabama, right? But I think that stage is really, really important. And so I'm curious whether that resonated with you guys.
Eve, I'm going to call on Marlena David, but could you just quickly though, can you say a word though about the Alito concurrence in Rothgary and his statement that there's no right to a pre-indictment investigator? Because that's kind of an unraveling of the Powell.
Yeah, except that it was an Alito in a concurrence, like no majority
But
joined
look at who
that.
our look at
Yes. No, I agree. And that's why I think they should do it under state constitutions too, right? Which I say. But look, and I think there's a difference between saying there's no right to a pretrial investigator versus there's no right to a lawyer during an investigation period. I actually think there are distinctions there, because the body of law about access to investigation and experts and social work and all of that tends to lie in a due process vein.
yeah.
And the
Okay.
access to the lawyer tends to lie in the Sixth Amendment vein. And so, I mean, I think there's a way to
Okay.
thread that needle, but I'm doing, lawyer work there.
Yeah.
I admit it.
Okay. Marlena, I hope I'm saying it correctly.
Yes, thank you very much. Hi,
Hi,
Eve.
Lottie. How are you?
Hi. Thank you so much for the paper. It's very timely for us too in Michigan. And I'm actually wondering what your thoughts are about whether the analysis that you've applied here applies in the appellate context. We are having delays in the appointment of counsel on appeal in Michigan. And I kind of like cringed when I heard you say they even have a name for it, the dead zone, because we even have a name for ours. It's the list exhausted. And that's what we've been referring to it as when we were not able to find counsel on appeal. And so I'm just wondering your thoughts about the application of this analysis in the appellate context. Keely Blanchard and I, Keely is from Max here in Michigan, and we're listening for our legislative testimony that we're going to be preparing for. And just if you had any thoughts about the appellate context.
Yeah, I will say, I think the arguments can be made under due process and equal protection, which is what the right to appeal is more grounded in than in the Sixth Amendment right to counsel. Unfortunately, they cut that off, right, at the appellate level. I do think like there's a way, the question is going to be, when does it become fundamentally unfair, right, or deny poor people who don't have access to appellate lawyers the same access to justice as wealthier people who do have access to the lawyers. One thing I think that might be helpful, this comes from the Roberts case in Oregon that just came down. They did a super fascinating thing, I think, when they were doing their mandamus ruling. Because there's a big question, like, as I've mentioned, there's different timelines that all of these courts are instituting. So like, you should be released after 7 days. You should be released after 14 days. We should dismiss without prejudice after 45 days, 60 days, 90 days. Like there's just different answers. Oregon, in the Roberts case, they looked to some recent standards about typical case processing times in the state of Oregon. And they said 75% of our misdemeanor cases should be processed to completion within 60 days, and 75% of our felony cases should be processed to completion within 90 days. And so that's what they used to implement their timeline that said after 60 days, we'll dismiss without prejudice misdemeanors, and after 90 days, felonies. So I think the answer, like if I were thinking about how to craft it at the appellate level, I would want to know what are the typical and, normatively good, right, timelines for processing an appeal, and how far beyond those are the defendants who are waiting, right? And if there's a big delta between those two, I think you could make an argument that both under equal protection and due process, that it violates fundamental fairness and it gives lesser access to justice to people who are poor, right, and can't afford a lawyer than people who have the means to hire a lawyer. That's how I would think about doing it if I were crafting it. But that's, it's harder than the trial level because I think the law is clearer, right, with the trial, right? But I think there's some narrative, right, relevance and meaning to showing just how much longer your delay is than typical processing times.
Thank you. That's very helpful. I appreciate it.
Yeah.
Eve, when you and I met before the webinar, I asked you how we could be most helpful to you.
Yeah.
And one of the questions that you had back to me is, you outlined this kind of structural problem and you spoke about it in your PowerPoint. And you wanted to know if people thought that was overstated. And so I want to hand it back to you for a minute to maybe talk a little bit more about what you're thinking there, because we have folks on this call from on the Zoom who are in mixed systems, state institutional systems, and in states that are primarily appointed counsel, most particularly in rural areas. So you got a good diversity of practitioners here.
Yeah, I mean, I want to be clear and I want to make sure. I'm always nervous. I write a lot about structure of systems that preferences institutional defender offices over assigned counsel and flat fee contract systems. And I believe that. I try very hard, both in the writing and whenever I'm presenting it, to say, I am not here to indict any assigned counsel lawyer or any individual assigned counsel system or any contract. Like, there are really wonderful assigned counsel and there are really shitty public defenders, right? It's not about the individuals, it's about the structure of the systems. And so here, I want to be clear, like, I'm not sitting here saying, oh, if we only had more institutional defender offices, we would never have delays. I think that's pie in the sky, and I don't think that's true, because I do think as long as we significantly underfund indigent defense and overcharge people, and as long as lawyers want to go to big law as opposed to doing public defense, which I don't understand, but appears to be a national trend, then it's going to be the case that it's going to be hard, right, to solve these delay problems. But I think that the structure of the system is part of this puzzle that I think is underappreciated. And so that was the goal in pointing that out. And it connects to the larger project, which is, I do think it is better to push for more institutional defender offices. And I think it's better for everybody. One of the things that people will often say to me, and this is like near and dear, I know, to Pam's heart with rural defense, is it's really hard to have institutional defender offices in rural areas where you have so few lawyers. But it's interesting to see the research that talks about in states that have strong institutional public defender offices, they are better at coming up with creative ways to provide access to justice in rural areas, whether it is through regional defender offices or like squads, right, of lawyers that they sort of second out to more rural areas, or development of pipelines. I just think, if some of you are familiar with Sarah Mayu's sort of historical work on
Yes.
the development of the right to counsel. And I mean, I love Sarah's work. And I think it's interesting because if you speak to Sarah and you ask her, like, historically, she will explain that the Gideon right, it was an individual right to have a lawyer to represent that person, that there was no contemplated sort of systemic role of the defender. And I think that is something that has changed remarkably in the last 60 years for the good. And you can see that. I think it's like Eric Fish and Chesa Boudin have a recent article that is about like the role of defenders as pushback against other branches of government. And I think if you look at institutional defenders now, a lot of the institutional defender offices, they represent individual people, but they also have like litigation, right? Legislative lobbying branches, structural litigation branches, participatory defense hub, relationships with community organizing that tries to like engage in larger policy proposals and issues for the communities that they serve. A lot of chief defenders are part of criminal justice coordinating councils that involve like the chief defender and the chief prosecutor and the chief judge and the warden and the sheriff, and to try and solve problems. And I really think it's important for defenders to have that seat at the table and to play that role. And it's super hard for an assigned counsel system or contract system to do it.
So can I ask, I'm going to just ask if we have a couple folks here from Texas, and Texas really has been the leader in both regionalizing rural indigent defense and also coming up with alternatives to a simple appointed counsel system, namely through the MAC. So I know we have Joel and Kenitra here. Is there anybody else or either one of you who want to say something in response to what Eve's talking about and the challenges of coming up with an institutional public defense structure in the context of a deeply rural setting?
I suppose I can talk. So when our agency first came into being in 2002, public defenders were very unpopular. But since 2016, the the number of private attorneys willing to take cases has just dropped every year. And most of the people that are taking them are very old. So right now, public defenders are very popular. The real obstacle is probably adequate money to fund everything. So if the state were willing to give us, $100 million, we could probably fund a whole lot of programs. It's just, I don't know if they're just going to hand us $100 million.
But Joel, can you say a word though about what, because you do have had this very interesting process of getting buy-in on these rural defender offices. In a lot of places, you think about public defender structure being imposed top down, right, by a legislature once counties either no longer have responsibility or refuse to exercise it. Y'all have a very different approach to building those offices.
Yes, in Texas, they're funded very often through improvement grants from our agency. So the county asks our agency, we're a state agency, and we give a grant to the county. And for a regular office, it's like a 5-year or 4-year grant where we provide 80% of the funding in the first year and it drops down to 20 and then they're off. With a rural regional program, we'll fund them in perpetuity. We'll fund 2/3 of the program. And that's very attractive to a commissioner or somebody that's very fiscally responsible, or they feel that increasing taxes is a bad thing. They may feel good or bad about the right to counsel, but they don't feel this is something they can pass up. There are a lot of jail costs that are hard to account for, but once you start providing 2/3 of the funding and you see the jail population shrink, even conservatives think that's a good program.
And Eve, also, I think to your point about kind of the challenges of building institutional defenders in rural areas, they've done a really good job in Texas regionalizing in part as well, I think, because if you want a public defender office, there's a fair amount of local commitment involved, but it means that you have a local bar on board, and the private bar kind of likes it because it puts some structure and some predictability into what they can anticipate. So it deals with a lot of those financial pressure problems that you talk about in the structural challenges section. So I don't know if that's helpful to you, but I think the Texas programs are worth looking at. We are at the hour, and so this is usually where we start to wind down, but I feel like in many ways folks are just getting started. Does anybody have any additional thoughts about just the structural piece and the challenges of appointed counsel? I'm getting the sense that Blake might, unless that was an auto response there. Oh, maybe not.
Yeah, no, sorry. That was just my colleague left the room, and so now the camera focused on me. Sorry.
Oh, okay. Well, that was my professor's instinct. I've got eye contact or almost. I'm going in. But I'm wondering, does anyone have any other thoughts about that structurally? Jason?
Yeah. Hi, I'm Jason Shores. I'm the director of the Office of Public Defense, and I'm in Snohomish County, which is in Washington. And I have volunteered frequently with the Bar Association in Washington. And we've gone through sort of a big change with caseload standards. But I think, I having gone through that big push for caseload standards, I have come to a similar conclusion that delivery systems are an equal part of the challenge that we face in providing good representation and other support services for our clients in order to get effective assistance. And, I hear you. It was, when you were talking about delivery systems and talking about assigned counsel versus firms, it sort of opened my eyes to that being the definition of a delivery system that is different than what I use, which is that we have a very decentralized public defense system. It is not state run. And so that delivery system, that choice of a delivery system, a non-decentralized system, creates other kinds of obstacles. And really, as you've been talking, I've been thinking about the way those two choices, both the decentralized system and also a system which may or may not rely on assigned counsel more heavily, can really also double down on the problem. And I think that is something that has, Oregon, for example, has met a little bit of a leg up. They have some little more centralization, maybe, like in some ways, but still has this reliance on a contract model system. But, as you're talking, it also strikes me that no matter where you go, we in my jurisdiction have a firm. It's a contracted firm, but they're a nonprofit public defense law firm and they do 99% of the work. But even in many jurisdictions, you're still going to have a reliance on assigned counsel for conflict cases. Sometimes they're used to address capacity issues when there's overflow of capacity, or various circumstances that, like, COVID happens, things happen. And so, even where you do have firms, you're still going to have a reliance on these systems that are known inefficiencies. And, like, locally, as I look at my budget that blossoms year on and year out, the criticism that comes where I see the biggest explosion is in the assigned counsel. Like, the other costs are relatively stable. Like, from a county council or county commissioner or executive's perspective, there's a stable cost in that law firm, and not a stable cost as we get a varying degree or varying number of conflict cases that go to assigned counsel, or cases of various sorts. And it strikes me that when you don't have a regional system to manage that, it becomes hard for those assigned counsel attorneys to also practice in a system that is decentralized, that has different rules, different payments, different obligations, different reporting requirements, and et cetera, as a case may be. So it really does also impact someone. And then each of those jurisdictions are competing against each other for all of those assigned or limited assigned counsel. So again, just adding rural factors, which I think was a part of your other, is another thing where there may not even be a full caseload for an attorney to live a full public defense lifestyle in a jurisdiction. So the absence of that kind of organizing outfit, whether it be the state or some other kind of system, is really problematic. So I think you're really onto something. I mean, I hate to say that the underfunding is not the problem, or the caseloads and, like, the work and the stress of, all these other things that we've identified are not part of the problem. But I've also come to a similar conclusion, if that is helpful to you along the way.
No, that's great. And I will say, I will put this in the chat for those who are interested. This is the article that I wrote a couple of years ago on problematic structure that is exactly on the point, right, that Jason is mentioning. And in that, I am a fan of statewide systems for the reasons, right, that Jason is describing. But I want to say, as a caveat, not necessarily statewide systems where every office is cookie cutter, which is the problem with lots of statewide systems right now. Like, in a lot of statewide public defender systems, the system is structured so that, like, every district, county, parish, whatever you're going to call it, right, like, has the exact same structure and the exact same model, and everything is uber centralized. And so that's why you get, like, in California and New York, whatever statewide idea comes up, like the Bronx and Alameda and, like, all these, like, no, don't mess with the good thing, right, that we have going. But I would imagine that you could have statewide structure and organization and still understand that maybe you have, like, a holistic defender office in your city, right, where you have the resources and the ability to do that, but you would have, a regional defender model that's more traditional to account for some of the counties, et cetera, that, like, not everything needs to be cookie cutter. But for purposes of data collection and lobbying and organization and resources and recruitment, like, I just think the statewide is a lot better. I make that point in that article rather than this one. This one is more agnostic, right? This is much more about, like, if you're worried about delays, regardless of whether you're structured at a county or a state level, if you're relying heavily on assigned counsel and contract systems, you're going to have more delays. And so the push to more institutional defender offices, and I kind of think it is a little bit of a baby step. Like, if you're in a county-based system, the more institutional defender offices that you have in your state, the better able you might be down the line to transition, right, to a state structure. It's just it's hard. I mean, Idaho has just gone through the transition from county to state, and it's been hard. And Montana did it in the last 20 years, and it was a rocky road, right? So it can be done, but it's challenging to do it. So I'm kind of with you on that. And I also think, like I say in that article, I think it's great to have institutional defender offices. I think you should also have conflict institutional defender offices in the jurisdictions that have the caseloads to support it. And yes, you will always need assigned counsel for tertiary conflicts or for overflow or for whatever it is, or for conflicts in more rural areas. But it's about the percentage of reliance on that.
Yeah. Eva, I also guess I want to flag for folks who may be less familiar with the scholarship on this, that, just to tease this out for some folks who may not have thought about structure in the way you have, that I think what you're talking about here is oversight. And, we can think about, the governance or the structure of public defense in terms of where's the money coming from. You can think about it in terms of who's setting the standards and collecting the data, or you can think about it in what's the delivery model. And so what I hear you saying is state oversight on standards, state responsibility for funding, with local delivery models being accommodated to what the jurisdiction requires, right? That
Yes.
seems to me to be the best practice that you're describing. And that's something like what Jason was just saying. Of course, in Jason's scenario, what's going to happen, I mean, I hope it won't happen, but the likelihood is that someone's going to say, well, yeah, the problem is that these caseload standards are letting you send the cases to assigned counsel, and it's going to go up, and that's always the risk. But that's the secondary problem that Eve's just said, you're going to have to get there. Anything else that we can help you with, Eve, or that folks want to check in about? And thank you for posting that link.
Yeah. No
Yeah,
problem.
and I can get you the Chessie. Let me get you Chessie's article. Was
Yeah,
that to the?
That's Chessa's art. That's the article.
did find it.
Chessa and
Okay.
Eric, right? That link.
Okay. And did you put yours in too? Good. All right.
Yeah.
So anything else we can help you with, or other questions folks have about resources, about, I know some of you are thinking about how to handle these issues in your own jurisdictions. You can also, if you're feeling like you can't say it out loud, chat is still available.
If you're thinking about the issues in your jurisdictions, I will say, like, the reliance on writs has been super fascinating, and every state has the state highest court has superintending power over the lower courts, and they have these writs.
And I will second that, simply saying that, we used them back after Katrina, and they were remarkably effective. Among other things, there's nothing that will get the bar's attention or the governor's attention faster than judges saying they're going to start releasing individuals because they're unrepresented. It's quick, and the worse the case, the more attention you get. If you have the right judge. So I would double down on that.
Yeah. I mean, I like the 1983 because it does enforce this dialogue where the political branches have to come up with fixes, but you have to have the right political climate, right, to do that. And there are some jurisdictions where that's just going to be a no-go, and others that might be more amenable. Like Maine was a great ground for the 1983 because they had fully an assigned counsel system. They were starting to think about institutional defenders and toying with the development of those. There was like some amenability to changing something on the other side. And so it was a good moment, right, to strike for that. And you'll see that, like, it worked in Missouri too, right, at the trial level for that short period of time. So it's a question of political will and, what the climate and temperature is. But the writs, I think, have worked in jurisdictions where there's been a lot of reticence on the other side to do anything to fix the problem. And the judiciary finally was like, I'm fed up. Like, I can't have thousands of people on wait lists for extended periods of time. And if you won't do something, I will. And that, it's going to have to catalyze some reform.
So I will save for another day conversations that we all might have about the accountability prosecutors have and how many cases they're bringing. And simply ask whether anybody else wants to check in. If not, I want to encourage you to take the time. If you haven't had a chance to read the article, please do. I get a lot of articles to read. It's not, Eve will tell you, not always fun. I really enjoyed reading this one. It's important. It's timely. There hasn't been enough work done on this. For those of you on the call who are practicing defenders and these issues are coming down the pike for you, please take a moment to look around at who's on this call. Eve, myself, some of the folks on my staff. Everyone who's here is here because they're interested in and committed to these issues. And when the time comes and it's your moment and you're ready to file something, let us know, and we'll be happy to provide you with lists of resources and people to contact. And I think I can speak for Eve and say that I know she feels the same way.
Yeah, I put my email in the chat, so feel free to reach out.
Good. And Jason, you want to add something?
Yeah, just to your point, to Pam, like this point about over prosecuting, I just kind of want to add something to that. Like, one of the things that we've been thinking about locally as a local economies collapse and there's less funding available for everyone, including public defenders, is talking about what will happen or trying to model what will happen if there are reductions of public defenders and trying to model that not just in FTE or lives and all this stuff, but in cases that cannot be
Yeah.
filed.
Yes.
Like, what does this mean? If you don't have us, then that means, and in some ways, that may be a good thing. We may say,
Mhm.
if we stop doing all these contempt proceedings, we wouldn't need this many lawyers or something like that. But in other ways, we may say if we stop putting, having all these kind of low-level felonies or low-level misdemeanors
Bullshit,
or
drunken disorderlies.
yes, on your various, including on your jail calendars or your taking
Mhm.
up jail space, thinking more systemically, then I do think you can start doing what you're talking about, Pam. But I mean, to Eve's point, I think you need a public defender office with data to start
Mhm.
being able to backtrack that way.
I
So,
agree. And there is an office, I can't remember where Eve might know. Who is it that's keeping a running tally of how many quality of life misdemeanors are being prosecuted? Do you remember?
No, I don't remember which
There's a
office
public
that
defender,
is.
and there's an
Yes.
institutional defender that is
Yes.
keeping a running tally of how many
Yes.
of these nonsense cases are coming in and what they're costing. And
Yes.
every time the prosecutors say, well, you should just take more cases. Their answer is, well, I can't because I'm in court on these 7,000 nonsense cases. And I wish I could remember who it was, but yeah, Jason, I think that's exactly right.
It's also super interesting because if you look at I cited to it in the article, there's a link in the article, but the 30-day report from Maine after the judge said you've got 30 days to come back and tell us what you're doing includes in the litany of things that they were doing a very hard push to get the prosecutors to change their charging practices. And the prosecutors dumped certain cases in the course of that 30 days to get the number of delayed people down out of fear for what would be coming from the trial judge if they didn't. So, I mean, that clearly was on their radar screen too. Whether that would have lasting effect is another question, but it's in there.
Yeah. All right, well, we're going to wrap it up because we got just 2 minutes left and we try and end these things right on time. Just a couple of quick announcements. For anyone who is working on these issues, for those of you who are researchers and academics, if you have a work in progress you want to present, particularly if it's on Sixth Amendment issues, prompt access to counsel, workloads, please let us know. We are always delighted to host a workshop for a great paper. For those of you who are practitioners and either are thinking about litigation or looking, again, you have our contact information, you have Eve's contact information. I think between the two of us, we can probably get you to any other lawyer's information who you might need. And lastly, I just want to put out a call to say that there are lots of resources on day one representation on our website. Very shortly, we will be rolling out some new resources on how to apply the National Public Defender Workload Kit, like a toolkit on how to actually use it. And obviously that is a very germane laughing. Yes, and that is obviously very germane to many of these conversations. Please don't hesitate to reach out. Let us know what else you'd like to see more of. We are here to serve this community and serve it as well as we can. Please don't hesitate as well if you have thoughts or feedback to let us know and share them. This webinar will be posted at some point, assuming that Eve's on board with that. We'll make it available online if you want to send your colleagues to it. And we will look forward to seeing you next time and seeing you sometime soon. Thank you all so much. Good to see you.
Thank you.
Yeah.
Wonderful presentation.